Case deny. What can I possibly do? In this video, we are going to be talking about denials because sometimes case get denied. We don't always win. And when a case is denied, we have to take the next steps. In this video, we are going to talk about those 4 steps, 4 different scenarios. My name is Bijoux Ngwanda, as you know it. I'm an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also follow me on all platforms. Links are in the description box below. By the way, USCIS is raising their fees, as you know it, effective April 1st, 2024. If you are eligible for any type of petition with USCIS, I strongly suggest that you file by March 15 of this year, because at least if a petition gets rejected, you will have time to file again under those old fees. Otherwise, you're going to have to file with those new fees starting April 1st, 2024. And if you need a consultation with me, my friend, you can schedule it by using the consultation link in the description box below. Let's get right into the topic. If a case gets denied, what can you possibly do? In my personal opinion, there are 4 things or 4 ways to go about it. The first thing is to start over. If you cannot start over, then you can file a different type of petition. If you're not eligible for another type of petition, you can appeal. If you're not eligible for appeal or there's no valid reason to appeal, then you can wait for the case to be referred to the immigration court. Eventually, you can either ask for a dismissal or administrative closure if you don't have any type of relief in terms of defending yourself in the immigration court. Let's start with the number 1, starting over. In what type of scenario can you really start over? I'm going to give you at least one example. Say, for example, I-130 has been denied because you introduced maybe false documents, or you introduced documents that were not sufficient. If you don't have additional documents to file an appeal, or you are not eligible yet for a waiver or something around those lines, the best solution is to start over. Because I've seen cases where people have started over and gotten a solution as opposed to people who try to file an appeal with insufficient document. Because remember, if somebody wants to file an appeal, especially using the form I-290B, if it's a motion to appeal, you have to have new sets of facts. If it's a motion to reconsider, it has to be a mistake in the law. And sometimes when the standard hasn't been met, it's difficult for you to file those forms. I'm going to go to the appeal in the next 2 minutes or so. But remember that filing or starting over could be a best option for you. Okay? I have a client who basically came to me because the case was denied based on the fact that they did not submit a translation of a document that USCIS requested. That's really the simple reason why the case was denied. But unfortunately for that person, when they file the appeal, I always tell people, when you are filing an appeal, of course, the person had new facts, right? They can file an appeal using the form I-290B, but they choose to go with EOR 29. This is the thing with EOR 29. Even though the fees goes to USCIS, but the appeal will go to the Board of Immigration Appeals. And remember, with BIA, cases are taking between 2 years to 4 years, even 5 years. So in that specific circumstances for that person, because they choose EOR 29, like they choose to go to BIA, the case is still pending. I told them, you'd be better off starting over. Because in 1.5 years, you have a response for your I-130 petition instead of waiting for BIA, and you don't know when BIA is going to answer that appeal. I've done it with somebody whose case has been pending with BIA since 2018. And we started the process with that person in 2021, and we got the response in 2023. So still the appeal is still pending. You see the difference? So that's my suggestion. If you can start over, you'll be better off starting over. Filing an appeal. You can file an appeal using the form I-290B. That's the best way to go, in my personal opinion, because again, as I said, EOIR 29, even though you pay the fees to USCIS, but the case goes to BIA, which might take longer than necessary. So, but if you file the form I-290B, even though it doesn't give you the processing time frame on the USCIS.gov website, you can follow up with USCIS. You can get your congressman to follow up. You can call the ombudsman's office to follow up, or you can sue USCIS if the form I-290B is taking longer. In order to file an appeal, file a motion there's a motion to reopen and the motion to reconsider, right? By using that form I-290B, motion to reopen, again, you have to have new set of facts. Motion to reconsider, you have to have, it has to be a mistake in the law that the USCIS made, okay? The third option, as we said, will be to either wait, right? That was the fourth option, but let's just go with wait. If you wait because you don't have anything else, once you go to court, the case gets referred to court, at least you have the option to ask for a dismissal or administrative closure for humanitarian reasons. We've done it before, and at that point, if you have a child who's a US citizen, the case can still be pending until the child turn 21, so that the child can petition for you. I mean, the case will be administratively closed, and it's much easier to reopen a case that has been administratively closed, okay? The other option we talked about was to file a different type of petition. Let's say it was a mistake because you maybe under, let's say, choosing between T visa or U visa, maybe the best option for you was U visa, you chose T visa. Starting over, filing a different type of petition will be best in that type of scenario. Another scenario will be, let's say the case get denied because of lack of jurisdiction by USCIS. In that case, what you will do is you will go differently, right? You will move differently. You will start with ICE first, motion to join motion to reopen, joint motion to reopen, removal proceedings, and dismiss or terminate so that you can adjust status with USCIS. If ICE refuses to join, you can file sua ponte if that's your first time, and let the judge decide. So those are the four ways or four options a person can have in terms of when a case is denied with USCIS. Denials are not the end of the world. As I was telling one of my clients last time, The case got denied because we did not meet the requirement, statutory requirement, to waive some type of alleged misrepresentation. So we tried to argue about the materiality of misrepresentation, basically telling them that, well, it wasn't material, look, because of this, because of that, but USCIS did not agree with us. So I told my client, in this type of scenario, it's best for you to file another type of petition. So revert back, maybe you had a asylum case before, revert back to that, because I don't see that if you go to appeal under those circumstances, it's not going to work either. So this is how we go about those appeals. And sometimes you just wait, you know, if a case gets referred to court, you can try to dismiss it. And eventually, if you have a child, and the child turned 21, then, you know, the child can petition for you. Or if you don't have any other option, at least if you dismiss the case, then you are not going to have the challenges or the stress to deal with some type of order of removal, you see. And some people, you know, they take voluntary departure if they really like fed up, you know. Denials, difficult to deal with, but you know, it's life. We have to deal with things the way, once they present themselves to us, we still have to deal with them. So that was it for today. I just wanted to give you some options, open up your mind, and see if there's something we can do about any type of denial that you might have. If you need a consultation with me, you can schedule it. And the reason I want you to schedule the consultation is because you will get guidance. Everybody, when they schedule a consultation with me, they get some type of clarity. They get some type of guidance, clarity, and what to do next. If there is something that needs to be done next. If there isn't, then of course we'll tell you as well. But if you call just to ask questions, my friend, I'm not going to answer them because I already told you consultation fees $175. If you need it, you call. If you don't need it, then you don't call. As simple as that. Until next time, bye-bye.